And of course, you'll know that Khumalo had asked for her testimony not to be broadcast live. The judge ultimately deciding this morning no compelling reason for granting that application. It's an important ruling, and it's one that entrenches the principle of open and accessible courts here in South Africa. Let's discuss this trial now with media lawyer from Wentzel attorneys Dario Milo. Dario, thank you so much for joining us. You know, you cannot help but draw parallels between this case and that of Oscar Pistorius. The Paralympian was ultimately found guilty of murdering his girlfriend in 2013. Did that trial, which was broadcast mostly live, as ordered by the judge who had to make the decision, Senzo Meyiwa, did that set really important precedents for South African law?
Absolutely, Sally. That was the first case where a criminal trial had been broadcast live, and it was broadcast, if you remember, by way of a combination of some witnesses giving evidence where only the audio could be broadcast, much as is the case as ordered today. And with other witnesses, they had full visuals and audio being broadcast as well. The distinguishing factor was that all the state witnesses, the professional state witnesses, such as the police and the experts, gave evidence with video and audio broadcast, via video and audio broadcast, whereas other witnesses, such as Oscar himself, gave evidence where only the audio was broadcast unless they agreed that it could be audio and video. So it was a combination, but it certainly set a precedent, Sally. And the precedent was completed in a later case, the Van Breda case, which you'll remember. That went all the way to the Supreme Court of Appeal. And in that case, the court said that the default principle is that proceedings should be broadcast or streamed, regardless of the nature of the proceedings, criminal cases, civil cases, appeals, trials that begin in the courts ab initio. And that's a principle which therefore means that if someone doesn't want to testify live, like the witness in this case, they have to do the running. They have to make the application and persuade the court that there's good reason that they shouldn't testify live.
Are the rules the same for whether you're a witness in a case or, in fact, the accused? I mean, I'm thinking of Oscar Pistorius. Was it his decision to be live, for his audio to be taken live, or ultimately didn't he have any say in the matter?
Well, in the Oscar case, while the prosecutors agreed that the default for the trial would be audio broadcasts, that's the NPA, Oscar Pistorius didn't agree, and he said there should be no broadcast or streaming of his evidence at all, or of the evidence of any of the defense witnesses. And what that meant is that when the case went before Judge Mlambo, as you say, he had Oscar's version, and he had Oscar's arguments, and he had the NPA's arguments, and he had our arguments for the media. I represented Prime Media and MultiChoice in that case. And the judge had to make a decision, and the decision he made was a very nuanced, balanced decision, which in the public interest said that because of open justice, there has to be some broadcast or streaming of this trial. It's a matter of massive public interest. It has attained worldwide attention and media publicity. And therefore, there was this combination of audio and video, which Judge Mlambo granted, none of which Oscar agreed to. So despite the disagreement of the accused in that case, the court nevertheless overruled that because of the public interest.
And why is public interest so important? I mean, yes, we understand the open court system, but that sort of suggests that you're prepared to go to the court and sit there, because, of course, not all trials are broadcast live. You have to take a letter to the court and ask for permission for each case. But even then, the media is only going to cover the cases that are either high profile or have some compelling interest. Why then is it important for them to be broadcast when you could essentially go to the court yourself?
I think, Sally, because the idea of being able to walk into any court in the country is a very nice idea in theory, but it's only professional reporters who really can do that, and perhaps students and others who take an interest in it. Geographic reasons of time, etc., mean that ordinary members of the public, citizens, who might want to follow a high-profile trial would not be able to, simply because they can't get to court. And if the principle is of open justice, that pretty much as a general rule, with certain exceptions like cases involving children, you can walk into any court in the country and sit and watch what's going on, and in fact get court documents that have been filed, and you can write about it, and you can listen, and you can tweet about it. Then it becomes far more understandable to say, well, if we have the technology today to be able to broadcast or stream what's happening in court, it gives far greater effect to open justice and to the rights of citizens to participate in this public interest, participate by way of watching live, being able to then engage on that and to debate, and of course to witness how the justice system works and how criminal cases and civil cases work, and how the testing of evidence takes place.
Yeah, and I think it was Dan Rosengarten who acted for the media in this particular case, saying that, in fact, Meyiwa's family not able to travel necessarily to every court date, but also some of the accused not able to travel to actually hear it. So they want to hear what is said as well. And I just thought so interesting what Zandile Khumalo had to say today. I mean, she didn't want this to go out live, but today she pointed to one of the accused, Bongani and Tanzi. She said he was one of the intruders on the night that Meyiwa was murdered. Now, here's the question. Hearing that information live, the public, we all heard that live, or we had the opportunity to do so. But hearing it live rather than later pre-recorded, which is what she'd said, does it build public trust in this case? Because let's face it, this particular case has been much delayed, mired in controversy. Do you think that it is important that it went out live?
Well, of course, if you take out the broadcast question, it goes out live anyway, in the sense that these days journalists will sit in the courtroom and tweet. So tweets will go out live in any event, and radio journalists will step out of the court every 15 minutes or half an hour and will report on what's been going on. So there's a slight delay on the reporting to listeners of radio. So it's not a far removed proposition to then say, why should it not be broadcast live? And in fact, there's a good argument made by Judge Sachs in one of the Constitutional Court cases that actually having a case go out live is better than having snippets, which has the capacity for perhaps misleading the public if only certain snippets are played. Whereas if you can watch a thing live, and of course with the Oscar trial there was a channel, so you could actually watch it during the course of the day and it was looped again overnight. But if you can watch something live, then you really rely on the media for a far deeper analysis, not just to tell you what happened in court, because we can all see that, but to analyze, to give an analysis of the justice system, the judges' adjudication, how witnesses performed, etc. And I think it actually deepens not just the credibility of the legal system, but also the public's, it serves a great educative value for the public, because the public gets to know about this and also to play a role in the public dialogue that happens on matters of public interest.
Do you think it's building trust in this particular case, given that there are so many theories floating around?
Well, absolutely, because the contrary proposition is that we have to rely on the traditional ways of consuming news about the trial. And there's nothing wrong with that. Print media, electronic media, radio broadcasters. But where you've got a far easier way for the public to gain access and to see what's going on in real time, it can only enhance the credibility of this particular case and of the judicial system generally, because one then doesn't rely on rumor, on hearsay, on perhaps what a friend may have read in the newspaper this morning and is conveying to you. You can actually get onto the internet, get onto a website and watch it. And of course you can watch it in a delayed form as well, because it is recorded and it's in the archive. And I think that actually plays a phenomenally important role. And Judge Moseneke, reflecting on the Oscar trial, that the fact that it had been broadcast, in a speech given shortly thereafter, was very complimentary of the way the media handled the broadcast and of what it had done to set not just a South African precedent, Sally, but also in many ways a world precedent for how trials should be broadcast.
Thank you so much for speaking to us this evening. That is media lawyer with Wentzel attorneys Dario Milo.